Hi guys, it's Kathy. I hope you're doing well. We made it to Thursday. Yes, sir. So, one of the servers called off yesterday, and the manager called off yesterday. It wouldn't have been a big deal, but we were packed, and there were 3 servers, me, and even though I only started there a couple weeks ago, the other 2 servers that were there yesterday, I trained. So the one poor girl never lifted a tray before in her entire life. So yesterday went about as well as you think. I got home so like we barely got cleaned in time for the next show. It was crazy yesterday. It was a crazy day. But we made it through. And I work today, and then I'm off. I'm not on the schedule again until I think Thursday. There's no shows. Isn't that crazy? There's just no shows. So I'm gonna be doing a lot of YouTube. I'm sleeping a lot. I'm excited. So I sat down today to put Judge Claymore on. Remember at the end of yesterday's stream, I was like, this is the guy I was going to show, but instead we showed the other one. And I don't know, this from 4 years ago popped up on my home screen, and I had to click, and I did, and now this is what we're going to watch first. And then we're going to go to Judge Claymore. This was from 4 years ago. So they're wearing masks. Well, she's wearing a mask. Here we go.
Okay.
Right.
Back on the record. All right. Any further proofs, Mr. White?
No, Your Honor, thank you.
Mr. Logerai?
Well, Your Honor, I'm thinking about the law right now, and
That's
there has to
good.
be a
You're
clear,
a
convincing
lawyer.
evidence that custody should change. I just don't think we have it here. The law is pretty clear. There has to be something significant before custody can be changed under Varga. And they're looking for a change of custody. I don't think they've met their burden, Your Honor. So I'd do a motion for directed verdict to deny their motion.
Mr. White?
Your Honor, this is a 8-year-old child who requires therapy because of her father's drinking and the different women in and out of the house. There can be no question that we met that burden, and whether Mr. Sylvius testifies or not, there's only one thing to do, and that's to change the custody here. We've clearly met our burden without any doubt.
Yeah, well, first of all, whether or not Varga has been met, I believe enough has been presented to meet the Varga standard. Whether or not there's enough testimony in the record to establish clearly and convincingly that the weight of the best interest factors weighs in favor of a change of custody, I'm not prepared to rule on that. I think I'd like to hear from Mr. Sylvius.
Sure, Your Honor. Thank you, Your Honor. Mr. Sylvius, I guess we should swear him in.
Yes. You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can put your hand down. Full name for the record.
Mitchell Ryan Sylvius.
Go ahead, Mr. Lugerai.
Mr. Sylvius, try to get out. I'm sorry, Your Honor. Let me kind of adjust here a second. The sunshine is nice, but not when I'm on Zoom. Mr. Sylvius, can you tell me prior to August 3rd or 4th or thereabouts, how you and Miss Ayers were getting along?
Kelly and I got along perfectly fine.
Okay. And how long have you guys been getting along? Were you guys getting along perfectly fine, as you stated?
We've been co-parenting and have had a healthy relationship since 2017.
And what is, tell me what happened in July of 2020. You bought a house?
Yes,
Okay. Who was your real estate agent for that house?
Kelly Ayers.
And did you specifically select her because she's Kim's mom?
No, Kelly had actually found the house and proposed it to me and asked if I liked it, and it just happened to be good timing.
Describe your house to me. How many bedrooms, how many bathrooms, that sort of thing?
It is a 4-bedroom house, 2-bathroom. It's got dining room, kitchen, typical house setup.
And where is it located?
How
It was
many
located in
cats
Napoleon,
do
Michigan.
you have,
And
sir?
how far do you live from Miss Ayers?
About 1.3 miles.
And who does all the transportation for parenting time?
I do.
And you heard testimony earlier that during the day you drop off Kim at her mom's house?
Yes, I do.
And when did that start?
That started at the beginning of COVID.
And why did you guys start doing that at the beginning of COVID?
Due to the concern of COVID, I used to have my family members help me out with Kimberly. But due to the pandemic and the cause for concern, we decided that I wanted to keep Kim with less exposure, especially to my older family members. So Kelly and I both agreed that it was better.
I take it in Kim's best interest to be with her during the day.
Yes,
And you heard testimony that mother does 100% of the schoolwork, was her testimony. Is that true?
no, it is not.
In what way is that not true?
For the end of the year of 2020, Kim did have to do Zoom meetings with her 2nd grade teacher when I had her. So we did do Zoom meetings off of my phone. And then at the beginning of the school year for 3rd grade, when she went back to in-person schooling, she did have to do homework. And I was helping her out with homework
Bullshit.
for the beginning of the fall year.
Lies.
One of the issues that came up in testimony was that you called Miss Ayers on approximately, I think it was August 3rd or 4th, early in the morning.
It would have been August 2nd, Sunday.
Okay. And why did you call her? What was the reason for the call?
I had a disgruntlement between my now ex-girlfriend and myself, and I seen a negative situation start to develop. And I want to be clear that I've always wanted to communicate and co-parent with Kelly, whether it be positive or negative, to keep the best interest of our child in mind.
Okay. And we saw some of those text messages. And after you shared those concerns
Wait,
with Miss Ayers, what happened?
what concerns? He had a fight with his girlfriend, and he calls his ex. What concerns did he need to share with her? I don't understand.
We had discussed later on Sunday when I picked up Kim from her parents' house. We had discussed certain options, what we could both do to help make my situation more positive. We discussed how we could potentially get Jasmine out of the house. And we also talked about how during a time of COVID, along with eviction, it can be quite a difficult task and perhaps a lengthy process. But that was the end result goal, is that we both wanted Jasmine out of my house.
And did Jasmine eventually move out of your house?
Yes, she did.
When did she move out of your house?
She moved out of my house on December 11th, 2020.
Okay. Has she ever been back to your house?
No,
Has she had any contact with your daughter whatsoever since December 11th, 2020?
none whatsoever.
And you remember we were in court in September?
Yes, I do.
Do you remember losing like 18 overnights with your daughter? Do you remember that?
Yes, I do.
Okay. At an earlier hearing on February 1st, you heard Miss Ayers testify that she told you that the child was seeing a therapist. She indicated, she said that she thought she would have the child see a therapist. Do you remember that?
Yes.
Do you remember her ever saying that to you?
No.
Okay. Do you ever remember her ever identifying a therapist to you?
No,
Has your daughter ever indicated to you that she was seeing a therapist?
no.
When was the first time you learned that your daughter was seeing a therapist?
It was during that court hearing in February.
Okay. Has the therapist ever contacted you?
No,
You've heard a testimony regarding things that happen at your house, partying, so to speak. Okay. Yes, you've
Yes.
heard that testimony. When Kim is with you, do you party, as they say?
no, I do not.
Okay. Tell me what happens when Kim is with you. Do you have people over?
I occasionally have people over, yes.
Who do you have over?
I can have some of my friends over. My brother has been stopping by more frequently.
What's your brother's name?
Zachary Silvius.
Okay. How old is he?
He's 20 years old.
How do him and Kim get along?
Him and Kim get along fantastically.
Is there drinking that goes on at your house in front of Kim?
No,
Okay. Has there ever been drinking in front of Kim at your house?
there has been in the past.
There has been in the past.
Yes,
Okay. Have you ever driven Kim?
No, sir, I've never drank an alcohol in front of my child before. That's terrible. Who would do something like that?
While drinking in the car?
no, I have not.
Okay. Have you ever driven Kim after drinking
No,
when not in the car? You understand what I'm asking?
correct.
Okay. Do you use marijuana?
No, I do not.
Would you be willing to take a marijuana test to prove that?
Absolutely.
Okay. As it relates to Kim's concerns about drinking, are you willing to consent to an order that says you can't drink any alcohol while Kim is with you?
Absolutely.
You're willing to do that?
I'm absolutely 100%
You're
willing
willing
do
to
that.
consent to not have anybody at your house consume alcohol
Correct.
while Kim is there,
Absolutely.
or use anything else?
Absolutely.
Are you guys ever up at your house when you do have people over up until 1 or 2 in the morning?
Never.
Okay. When people are over, how late are they over until typically?
If it's on a weekday, there's no later than 9 p.m. where people stay.
Okay. So this partying that Kim seems to have indicated is causing her anxiety to the therapist. Has Kim ever discussed that with you?
No,
Has Kelly ever Miss Ayers ever discussed these concerns with you since September?
no, Kelly has not.
Okay. And had she discussed the concerns, would you have taken remedial action? Would you have done something about it?
Absolutely.
Now, one of the things they indicate is the time that you spend with Kim. What do you do with Kim when she's with you?
We can go grocery shopping together because I know she likes to pick out some of her more favorite foods.
And what are her more favorite foods?
She likes macaroni and cheese. She likes to make sure that I pick up some of her more favorite snacks, such as Jell-O or Cheetos. She really likes to make sure that I keep ravioli stocked in the house.
Okay. What sort of other things do you do with her?
We go to the park.
What park do you go to?
We have a few parks that we go to. There's the park that's in Napoleon. We visit. We went there yesterday.
Okay.
There's another park that's in Brooklyn that we will occasionally go to. And there's also the playground at the elementary school that we will go to.
Does she seem anxious when she's around you?
Not at all.
Does she ever ask to spend more time with you?
Yes, she does.
Objection as to what the child asked, any hearsay.
Your Honor, I'll strike the question. That's fine.
Okay.
How would you describe your relationship with Kim?
Very positive.
Okay. And I already asked you, she doesn't appear to be anxious around you.
No,
Has she ever talked to you about, Dad, you're drinking too much or anything like that? Ever brought up drinking?
she's asked why I drink beer.
Okay. And what was your response?
I told her that I just like it.
Okay. And when did she ask you that question?
She's asked that over the course of the last year or so.
Had she ever asked it before?
Well, yeah, yes, it's during that 1 year span.
Oh.
Occasionally she'll ask.
Okay. And in terms of when you communicate with Miss Ayers, is it over the phone, in person, or text? Describe to the court how you guys primarily communicate.
Our primary communication is through text message. On occasion, we will discuss in person during exchanges on Sundays and Sundays only.
Why Sundays only?
Sunday is a little bit more of a relaxed time for us to communicate if we do need to communicate. Usually, during the weekday, I have to go to work. So when I drop Kim off at 6:30, when I drop Kim off, Kim gets out of the car, she runs up the driveway, up to mom's porch, and then Kelly lets her in the house. We'd never communicate at 6:30 in the morning. And then after I'm out of work, I will go pick her up. And Kelly will sometimes tell me that she has to go get Kim, or she'll just say something that, Kim did really good at school today, and that'll be about the extent. But primary communication happens on Sunday.
Okay. How about, do you guys text message each other?
Yes.
Right. And who lives at your house right now?
My friend Kinsey.
Okay, who's Kinsey?
Kinsey is a friend of my brother's.
Okay. Are you in a romantic relationship with Kinsey?
No, I am not.
Okay. And was your brother ever in a romantic relationship with Kinsey?
No, he was not.
What does Kinsey do?
Kinsey is a cook.
How long have you known Kinsey?
I have known Kinsey for about 2 years.
Does Kinsey drink in front of Kim?
No.
Okay. How do Kim and Kinsey get along?
Kim and Kinsey get along just great.
Okay. And you already indicated you're not in a romantic relationship with her.
Correct.
How did she come to live there? Is she paying rent?
She is paying rent.
Okay. And one of the issues came up with where Kim's room is located. Is there any issue with Kim giving Kim a different room in the house if she were to want that?
There's no issue. In fact, when Jasmine moved out, I had asked Kim if she wanted to change rooms, because she had mentioned that she doesn't like the doors to her current room. I asked if she would like to change rooms since one was available, and she said she did not.
That's what you would say, Your Honor. We're
That's
more than
fine,
willing
that's
to,
fine. That's fine. So
more than willing to call her as a witness if we need to.
No. So you asked her if she wanted to change rooms. As a result of that conversation, did she in fact change rooms?
No.
Okay. As it relates to so one of the issues that came up in testimony by Ms. Ayers was that it was your decision that Kim be an in-person school. Is that correct?
Partially my decision.
Okay, so tell us what happened.
So prior to the beginning of the school year, while Kelly and I were still under good terms of communication, we had both discussed equally what we would like to do for Kim for school this year. I was more erring towards the side of her doing in-person schooling. This whole COVID situation has definitely brought distress to a lot of people, especially younger children. I wanted her to go back to do in-person schooling so that she could have a social setting. I believe that Kelly had that same mindset as well.
Why do you believe that?
If she's going back to school, then she's somewhere, 5 to 12? I don't know. I'm guessing she's not a teenager. I'm guessing she's still young. First grade, second grade.
Because during the very beginning of the school year, for the first 2 days, Kim did attend in-person schooling. And I had even called the school to verify that. But Kelly then pulled her from in-person schooling to do virtual schooling because Kim had such a hard time adjusting to the new social settings, face masks, barriers, and all of the new restrictions.
How's she doing in school now?
She's doing just great.
Okay. And if she and you still help her with homework, or
I presently don't help her with homework.
why not?
Let's go with 8.
I drop
She
Kim
said.
off in the morning, and then I pick her up when I'm out of work. And since December, Kelly has not given me any sort of schoolwork, any sort of school scheduling. She has not provided me with anything as far as related to school. She's not asked for any assistance. So I have just assumed that she's taking care of all of it.
Prior to December, would she ask you for assistance with that?
No.
Okay. How would you do it then?
Prior to December, I was actually taking care of the transportation of on my end when I had her for my weeks to and from school.
Wow.
And when I would get her from school, she would have homework and we would do homework then.
Okay. And why aren't you doing the transportation now? Why that end in December?
Well, when Jasmine moved out and the negative situation had been removed, I was kind of hoping, and I'm still hoping, that we can both go back to a positive, healthy co-parenting relationship. So,
With Miss Ayers?
yes,
Okay. So you were kind of giving her something that she wants, like,
yes.
I got you. Your Honor, I don't have any further questions.
Mr. White?
Thank you, Your Honor. So let's go back to this August 2nd or August 3rd call, Mr. Silvius. You were so concerned about Jasmine's mental state and so concerned about the safety of your daughter, you called at like 3 or 4 in the morning and left a message with your ex-wife, right?
Yes,
You were concerned that Kim's life was in danger?
no, I never said that.
I'm asking you, were you concerned?
I was not concerned that my daughter's life was in danger, no.
Were you concerned about any danger at all?
I was concerned about her mental health.
When did you move Jasmine into that house?
Jasmine moved in the same time that I did, in late July.
July of 2020.
Correct.
So during the COVID, you moved in a stranger into your household. Is that right?
I wouldn't call her a stranger.
Did she live in your household before July of 2020?
No,
So you moved a new person during this COVID crisis into your home, right?
we had a prior relationship.
But you didn't live with her. You moved her into your home.
Yes,
And then less than a month later, you're making a call in the early morning hours to warn Kelly about issues, aren't
yes,
you? And then you followed up that said essentially that your daughter can't be around Jasmine, right?
I stated that I don't want my daughter around Jasmine.
Do you remember what you said exactly?
I do not remember exactly what I said.
Grab your phone.
Do you remember saying, do not speak to Jasmine? Kim's best interest is not in her mindset. Do you remember that?
I do.
Do you remember saying, right now, until she leaves, Jasmine is far from suitable for our daughter? Do you remember that?
Yes, I do.
So did you give Jasmine a notice to quit or move her out after you had to make this late night, early morning call
Yes,
to Kelly? So she moved out when?
she moved out December 11th, 2020.
Okay. So you've got all these concerns that you make this call on August 2nd or August 3rd. You don't get rid of her for months, right?
Correct.
Even though you got all these concerns, you still let her live there for all of August, all of September, all of October, and almost all of December, right?
Right.
The whole time that you have these problems, you don't move her out.
Correct.
Is it
Lozzie.
because you have a child with her?
Thank you, love.
No, I
Thank
do
you.
not.
Thank you.
Are you sure?
Absolutely.
Are you aware that the first baby daddy test came negative on her paternity claim for that little girl that was there at your house?
I'm not aware.
Because Jasmine didn't live with you alone, did she?
No.
She had a child, right?
Yes.
How old is that child?
Jasmine has 2 children.
Let's go with that first one. Is it 5-year-old?
Her first child, his name is Cooper. He's 6 years old.
And then what's her next child?
Her next child is Braylon, and she is almost 2 now.
And you're going to stay under oath that you're not the father?
I will say under oath that I am not the father.
So Kelly goes and tries to get an ex parte order based on what you did with calling her. Do you remember that?
Yes.
Now, you said you missed, 18 days of parenting time?
Yes, as well as her birthday.
You didn't file a parenting time complaint with the front of the court, did you?
Yes, I did.
And where's that at?
I don't have it on me right now.
Did you file a motion during that period of time to compel seeing the minor child?
No, I got with my attorney.
Did he file something?
Yes, I believe I did.
Okay. So
Sir, nobody asked you a question.
what do
Shut
you
up.
do to protect Kimmy from Jasmine since you didn't make her move out when you said you would?
Well, hold on, I'm gonna object to that question because he said he would make her move out in December and he did.
Actually, that's not what he said at all. I can get the date. You said she's moving out on, you remember in the text message saying she's moving out in August?
Yes,
Okay, so you say she's moving out in August. That turns out to be untrue, right?
correct.
So now you've got a situation where you're so concerned about your daughter's well-being that you call mom in the middle of the night. You say that the problem is moving out and she doesn't. Have I got it right so far?
Correct.
What are you doing to protect your little girl from this person that you won't have move out?
I don't leave him alone with her. I never did after that. And anytime that there was an issue that I seen that would be volatile or dangerous, I would take him and we would leave.
Now you heard Kim talk about, or you heard the therapist talk about all this stuff that was related from Kim. And if we're to believe your testimony, essentially every part of the drinking that little girl reports is a lie then, right?
Yes,
So you're prepared to have us put that little 8-year-old on the stand after you're done to talk about what she saw then, right?
We don't want the child to testify.
Oh, we're going to now.
Inappropriate.
We're going to now. So you're prepared for that, right? You don't want to change your testimony?
rephrase your question, please.
After you're done testifying, I'm going to call this 8-year-old girl as a witness to clear up exactly who's drinking when. Are you sure you want to have your sworn testimony as it is? Where that all this stuff where you've never drank around Kimmy.
That wasn't his testimony. He said he has drank around her.
I said I no longer drink in front of her.
And when did that start?
That started at the beginning of this year. I have some seriously developing health problems. All right, I'm trying to make my person better and healthier due to my underlying health conditions. And alcohol is not a contributing healthy factor to that.
So when's the last time you consumed alcohol?
Friday night.
Did you just find out after Friday night that you have a health problem that could be helped by not using alcohol?
I have cut down on my drinking. I never said that I have quit drinking altogether. I have significantly reduced my drinking.
Okay. So we've already established, I think, that despite your promises that Jasmine would move out in August, she didn't, right?
Correct.
How about in September? What steps did you take to move her out in September?
Jasmine and I were communicating, trying to keep the situation more positive. I was more or less hoping that she would be able to move out voluntarily, because I understand that with everything with COVID, it would make going through the eviction process that much more difficult.
Well, it sure looks like you're spending a lot more time trying to patch things up and keep things with Jasmine than you are throwing her out so that your daughter feels better. I mean, you made this call to Kelly. Don't you think it's time to choose Kimmy over Jasmine?
I did choose Kimmy over Jasmine. That is why Jasmine is no longer in my home.
4 months later. Because wasn't there another problem? Didn't Jasmine cause another problem with your family unit in December?
Yes, she did.
And what was that?
It was, I found out that Jasmine had called CPS against Kelly and her husband, Andrew. Found out that she had called Kelly's place of employment and reported false claims. And all of that, I was very aggravated against. And that's when I told her that she had to leave. I wasn't aware that she had done any of that. Kelly's a good mom. And I know that she would not let any harm happen to Kim in any manner whatsoever.
Didn't you say on December 6th, didn't you say to Miss McJames in front of in front of Kimmy, you should suck start the end of a shotgun and blow your brains out. Do you remember that statement?
I remember that statement, but it didn't happen in front of my child.
Again, we'll hear from her in a little bit. So your testimony is that she did not hear that in any way, shape, or form?
No.
You sure about that, right?
Yes.
Okay. You read do you want to hear the audio that exists of that? Hold up. Your Honor, we have an audio. We'll try to figure it out, but
Your Honor, I don't think why that's necessary. He says he said it. What's the point of it?
I think the audio is going to show that little girl was there, if I'm not mistaken.
All right, well, if you've got, it looks like
He's mistaken.
it's approaching 12 o'clock. We're clearly not going to finish. I need to find a time where we can conclude the testimony.
Okay.
I'm not available this afternoon. What I'm going to do is get with Dawn and have her get with both of you to find a time. I'm assuming we're looking at no more than an hour or two max.
I hope so.
For this witness,
But I don't understand, Mr. White. When we previously spoke, or I think it was on the record, you indicated you had two witnesses, your client and the therapist.
I'm calling a rebuttal witness, and that's that little girl.
Okay, well, I
I don't have a lot of choice here. We have a
I don't
therapist
think
who
that's-
clearly related all these stories, and then we have a defendant that says none of it ever happened. So we'll find out from an 8.5-year-old girl.
I think.
All right, well, whether or not the girl testifies, we're gonna have to leave for another day, gentlemen. I'm gonna
Okay.
close the record now, and Dawn will get a hold of you to find a new date.
Very
Thank you.
good.
Hold on. Hold on, let's look at this. Let's see if part 2 is available. I thought it was a quick little hearing. I'm going to look for this while I put on Claymore. And if I can find a part 2, we will watch it. I'm going to bring this over here. I'm going to go.
I have the sets of papers that I received.
I'm looking, guys.
I find different that in the papers I walked out of Porter County Jail with, it says one thing, it doesn't mention no
It says what? You need to speak a little louder.
It says it's a sworn statement of the officer, and these two papers differ. There's charges on this one that there ain't on this.
Go ahead and hand it to him.
Other people that walked out of jail, this is what I received. And on what I walked out of jail with only mentions marijuana. It doesn't say nothing about no methamphetamine. And that's a sworn statement of Officer Hart. I'm on kind of asking this picture.
All right. So
I found it now. I got to see if there's a verdict.
about the bottom of the page of the documents that you gave me, there's a box that says possession of methamphetamine. So the papers that you gave me show that you allegedly possess methamphetamine. That's the allegation in the new case. Do you understand all that?
I just didn't see the possession of methamphetamine. on
Well,
it.
it's there.
I was, like I said, I was more asking them.
All right, let me, before you ask any more questions, let me advise one of your rights is to remain silent, okay? In the petition to revoke your probation, you have certain rights. You're entitled to a hearing in front of me. Do you understand that? At that hearing, the state must prove the allegations by the preponderance. Do you understand that? You still have the right to face and cross-examine every witness, whoever would be that would testify at that hearing. Do you understand that?
Yes.
You have the right to have me issue subpoenas to have witnesses testify for you. Do you understand that?
Yes, sir.
You have the right to remain silent. You can't be forced to testify against yourself. Do you understand that? And you have the right to an attorney in the revocation matter. Do you understand that? If you cannot afford an attorney, I will appoint one for you. Do you understand that?
Yes, sir.
In this case, the allegation in the revocation matter is that the state of Indiana filed a petition to revoke your probation because you were charged with a new crime, which we're going to address in a second. So do you admit or deny that you were charged with a new crime?
To jail.
All right, but you can say you deny the new charges. All right. All right, now we're going to shift gears. I'll enter a denial on your behalf. In cause number 2510 F610989, you saw Judge Matty, I believe, on early October.
My notes show,
October 2nd.
yes,
And at that hearing, Judge Matty ordered the new case to be transferred to me. And that new case is one in which you allegedly possessed methamphetamine and down at the bottom of the page, those checkboxes that you allegedly possessed methamphetamine and that you possessed marijuana. And that was at 11:52 a.m. on September 26, 2025, at 101 East Chicago Street. And all you saw when you saw Judge Matzy, all he did was advise you of the charges and the penalties and then transferred it to me and set bond for you. Is that right?
Pretty much, yes. I should have been released the day prior, but something happened with the order.
That you have to.
I'm sorry, they had told me I should have been released on Wednesday, the day prior, but something happened when the judge signed the order. Nobody took me out.
All right. So, do you have the money to hire a lawyer to represent you in both cases?
You know what, Your Honor? Honestly, I work right across the street at a restaurant, and our hours have gone down. So,
Do you have the money? Do you want me to appoint a public defender?
if you could, please.
I am appointing Attorney Mitch Peters to be your public defender. You are ordered to appear on the following dates: January 5th at 9:00 for an omnibus hearing, February 2nd at 9:00 for a final pretrial conference, and March 30th at 1:00 for jury selection. Mitch Peters is now your public defender. The probation revocation matters will also be set for a status on January 5th at 9:00. Having said that, you are still on probation now. You aren't to violate any laws. You're not to test positive for any drugs, and you're to see Ms. Madrigal-Otano occasionally. Is that right, Ms. Madrigal-Otano?
Judge, he's on administrative probation, but I'll be checking in every once in a while.
All right. So I will call Mitch Peters. I will see you January 5th at 9:00, sir.
thank you.
We will be in recess for about 5 minutes once again.
it's going to take me more time to find that. So that is another day type deal. What did I miss? Do I need to fast forward? It looks like I need to fast forward. So I'm going to. Oh, look what I did. Hold on, I need to fix this. Now. Alright. Where did the judge go?
Xavier Vane. This is State of Indiana versus Xavier Vane, cause number 64 D02 2508 F6 9545. Defendants appear.
This judge, you've seen him before. We've seen him many times before. He's so good, and this is the way his dockets go. Normal, outstandingly freaking crazy. Oh my God, what did that teenage boy just do? Those 3 schools in 2 different states, and that's not an exaggeration. It's like out of nowhere we go extra super crazy.
Pro se. State appears by Deputy Prosecutor Holman here today for a attorney status hearing.
Indiana, but I don't think it's Elkhart. And I don't know which county it's in, but I can find out for next time.
Are you Mr. Vane? Have you been able to hire a lawyer?
No.
Are you working somewhere?
Yeah, I just started working.
Where are you working?
Amazon.
How much money do you make?
23 an hour.
Do you have any dependents?
Yes.
How many?
4.
Do they live with you?
No.
How many people do you support financially?
I support all my kids financially, so I think that'd be the only.
So you pay money to support
Yeah.
your kids?
Yeah.
Same date? Same date? Yeah. Would you like me to appoint a public defender to
Yeah.
represent you?
Yeah.
I appoint attorney Mitch Peters to be your public defender. You have a card that has his phone number on one side and should be these dates on the back side. November 17th at 9 o'clock for an omnibus change of plea hearing. January 12th at 9 o'clock for a final pretrial conference. And February 23rd at 1 o'clock for jury selection. Is that what that card says?
Yes.
Call Mr. Peters. I will see you in court November 17th at 9 o'clock, sir.
All right.
Indiana versus Danielle Gulick, cause number 64 D02 2509 F6 10665. Defendant appears via Zoom, appearing on behalf, or she's pro se. State appears by Deputy Prosecutor Holman here today for a initial hearing.
Will you raise your right hand, please? Oh, you need to unmute yourself first, though. Bill, microphone, there we go. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
What is your name?
Danielle Gulick,
Ms. Gulick, how old are you?
48.
Do you understand English?
Yes.
Are you under the influence of any drug or alcohol?
No, sir.
Do you have any mental or emotional disability?
No, sir.
The prosecutor is going to advise you of the charges that have been filed against you and the potential penalties if you're convicted of either of those charges. Mr. Holman.
Thank you, Your Honor. Count one alleges theft as a level 6 felony. That charge reads that on or about September 24th of 2025 in Porter County, Indiana, Danielle Gulick did knowingly or intentionally exert unauthorized control over the property of Walgreens with the intent to deprive the owner of any part of the property's value or use. And the property's value was at least $750, but less than $50,000. This is a level 6 felony punishable by between 6 months and 2.5 years of incarceration and a $10,000 fine. Count 2 alleges theft, a level 6
Wait, what did she steal from Walgreens? It's $750. I need to know.
felony. That charge reads that on or about September 24th, 2025 in Porter County, Indiana, Danielle Gulick did knowingly intentionally exert unauthorized control over the property of Walgreens with the intent to deprive the owner of any part of the property's value or use, and the person had a prior conviction for theft or conversion. This is also a level 6 felony with those same penalty provisions, and those are the 2 counts, right?
Ms. Gulick, do you understand what the 2 charges are against you?
Yes, sir.
Do you understand what the potential penalties may be if you're convicted of either of those charges?
Yes, sir.
You have the following constitutional rights. You have the right to a public and speedy trial. Do you understand that?
Yes, sir.
Your trial may be conducted in front of 6 jurors or me. Do you understand that?
Yes.
You are presumed not guilty. The state must prove you guilty beyond a reasonable doubt. Do you understand that?
Yes, sir.
You have the right to face and cross-examine every witness. Do you understand that?
Yes, sir.
You have the right to have me issue subpoenas to have witnesses testify for you. Do you understand that?
Yes.
You have the right to remain silent. You can never be forced to testify against yourself. Do you understand that?
Yes.
You have the right to an attorney. If you cannot afford one, I will appoint one for you. Do you understand that?
Yes.
I am entering not guilty pleas for you on both counts, reserving your right to a jury trial and ordering the state to produce discovery, including your criminal history, to either you or your attorney. So, are you working somewhere, Ms. Gulick?
No, sir.
What are your sources of income?
Right now, I don't have one.
Do you have any money to hire a lawyer?
No, I do not.
I think it's eggs. I think she took 3 eggs.
Would you like me to appoint a public defender to represent you?
Yes, I would like that, please.
I appoint Attorney Mitch Peters to be your public defender. We will give you contact information for him in a second, but you are ordered to appear on the following dates.
I was wrong. It's Elkhart because that's where Mitch Peters works. So I was wrong. This is Elkhart.
January 5th at 9 o'clock for an omnibus change of plea hearing.
Okay.
February 2nd at 9 o'clock for a final pretrial conference. And
Okay.
March 30th at 1 o'clock for jury selection in your trial.
Okay.
Do you have something to write on? We'll give you Mr. Peters' phone number.
You know what? Okay.
I need his card.
Go ahead. I do have it.
It's 219
Mm-hmm.
510
510
5908.
5908.
Yes, call Mr. Peters. We'll let him know. He's been appointed your lawyer. We'll see you January 5th at 9 o'clock.
Okay, thank you
then
so much.
I was absolutely right then. Maybe Mr. Peters works both counties.
Thank you.
You're welcome.
Ugh,
Judge, does the court show any attorneys on Zoom? Mr. Tavitas texted me a while ago. I didn't see the text just now.
There he is. Look at that.
Oh,
Hi, Judge.
there he is.
Yeah. Here, let's see who, well, Adam's here and we also have
Thomas
Joe
Arizum.
Roberts. Joe Roberts is here too. All right. Well, Adam, who's your client?
Thomas Arizum. He should also be by Zoom, Judge.
He was on earlier. We saw that.
Your Honor, this is State of Indiana versus Thomas Arisum, cause number 64 D02 2503 F6 3323. Defendant appears via Zoom, appearing also on Zoom is Attorney Tavitas. State appears by Deputy Prosecutor Holman. Here today for a status hearing.
And
Good
what
morning
is the
again.
status? Go ahead, Mr.
Yeah,
Tavitas.
good morning again, Your Honor. I apologize for not being there. I've got a dentist appointment, so sorry about that. This is something that I have spoke with Mr. Pavlovsky about. I'm hoping for working on a resolution. We might have to take a deposition. Judge, can we have that January 12th date? And if we don't have a resolution, then set it for trial. We'll accept all criminal rule 4 time.
Defendant's motion for continuance is granted. This matter is set for a status January 12th. Does 10 o'clock work, Mr. Tavitas?
It does, Judge. It does.
January 12th at 10 o'clock. If there isn't a resolution, we'll put it on the trial calendar.
Great. Thank you, Judge.
Mr. Ursum, you're ordered to appear. Do you understand, sir?
Yes,
I will see you then.
thank you, sir.
Sorry, Mr. Tavitas, for mixing that text. I apologize.
No problem. No problem, John. Have a good day. Bye-bye.
And Mr. Roberts, who's your client?
Mitchell Krolikowski.
Your Honor, this is State of Indiana versus Mitchell Krolikowski, cause number 64 D02 2507 F6 8142. Defendant appears via Zoom with counsel Mr. Roberts, who is also via Zoom. State appears by Deputy Prosecutor Holman, here today from Omnibus.
Go ahead, Mr. Roberts.
Thank you, Your Honor. There's no issues to address today. I have made a proposal as to what I think is an appropriate resolution to Attorney Pavlovsky, just waiting on a response from that. At this point, we're just affirming the dates that were already scheduled in this matter.
All right. The final pretrial conference of November 24th at 10 o'clock is affirmed, and jury selection that will begin January 5th at 1 o'clock is also affirmed, and I saw Mr. Krolikowski appear for just a second. But those dates are affirmed. November 24th at 10 for a final pretrial, January 5th at 1 for jury selection.
Thank you, Your Honor.
Thank you, Mr. Roberts. And your client was?
Yeah. Oh, it looks like he just unmuted. His picture's not on, but yes, he's been on since 10 as well.
Yep, and you're right. He unmuted. All right. See you in November.
Sounds great. Thank you. Have a great day, everyone.
And we have.
Party and Person are the only individuals left on my list.
We
Do you
have
see?
Anthony Person.
Okay. This is State of Indiana versus Anthony Person, cause number 64 D02 2507 F6 8069. Defendant appears via Zoom.
There we go.
Mr. Person, can you hear us?
Yes, I can hear you.
Okay. Defendant appears via Zoom. State appears by Deputy Prosecutor Holman. We are here today for a omnibus.
Not working. Not
You still live in Illinois, Mr. Person, and you're muted.
Yes,
Have you been able to hire a lawyer?
I have not. I plan on acquiring my own lawyer. I should be employed within a month. I've been uh, had a couple interviews that went well, so I should be employed within a. I'm assuming within a month, so I can acquire my own lawyer.
All right. So what we're gonna do right now, though, is just reaffirm the dates I had given you before. And those are November 24th at 10 o'clock for a final pretrial conference and jury selection January 5th at 1 o'clock. Do you understand that, sir?
Yes.
I will see you November 24th at 10 o'clock, sir.
Okay. Thank you.
We'll see you then.
Okay. Thank you.
Person, we just reaffirm dates.
Lastly, Christina Hardy. We show her via Zoom or no?
Nope.
Your Honor, this is State of Indiana versus Christina Hardy, cause number 64D0220 509 F6 9836. Defendant fails to appear. State appears by Deputy Prosecutor Holman. Defendant is pro se. Looks like we are set today for attorney status. And I'm showing that she was ordered to appear via this court's September 22nd order. State request bench warrant.
It looks like they're at the end of this docket, so we're gonna move on to something else because she didn't appear, and those are the only two people left on their list. And I thought he was gonna take much longer, and he just didn't. Let's move to this one.
Battery as a Class A misdemeanor, and that would be in CM 1027. You're also going to plead guilty to possession of marijuana as a Class A misdemeanor in CM 989, and you are going to admit that you violated your placement on probation in CM 968. Is that correct? Correct. Sir, the terms of your plea agreement indicate that for the charge of possession of marijuana, you will be sentenced to 180 days at the jail. However, that will be served on alternative placement on Elkhart County Community Corrections, it looks like. Yes, ma'am. The level of your supervision will be determined by Elkhart County Community Corrections. You will have to obtain addictions evaluation plus any recommended follow-up treatment. And you will pay the mandatory court costs, which includes the $200 drug interdiction fee. And you'll receive credit for 2 days served at the jail. For the domestic battery charge, you will be sentenced to 1 year at the jail. That will be suspended on probation at a level of supervision deemed appropriate by the probation department. You will pay the mandatory court costs, which includes the $50 domestic violence fee. And all of the other terms are left with the court's discretion. These sentences will have to be served consecutively to each other, meaning one after the other. Do you understand that? Yes, ma'am. For the probation violation, there is a recommendation that you be dishonorably discharged from probation and that you receive credit for 30 days at the jail. Is that correct? Yes, ma'am. But Mr. Perkins, I will explain in just a few moments the difference between the recommendation on the violation of. He's time served. Time served, okay. Never mind. So your time served on that violation, correct? Correct. Okay, so then talking about community corrections, through Elkhart County Community Corrections that can be either work release, electronic monitoring, or daily reporting, or it can be a combination of those levels of supervision. Do you have any questions about what that means?
No, ma'am.
For probation, that can be either reporting or non-reporting, or a combination of those two levels of supervision. Do you understand that?
Yes, ma'am.
Mr. Park, it is possible that you may have to complete additional programming or treatment in addition to the addictions evaluation possibility. That can include domestic violence programming, parenting programming, or mental health treatment, or anything like that. Do you understand that?
Yes, ma'am.
So it is also possible that the court can order that you have no contact with the victim of the domestic battery charge. I can also order that you pay the victim restitution if the victim suffered a financial loss. I don't know anything about the fact pattern right now. I'm just telling you generally the terms that the court can impose. Do you have any questions about that?
No, ma'am.
Mr. Parkins, in looking further through the written plea agreement, I see that there are initials that appear in the numbered paragraphs in the defendant's right section. There is also a signature at the end of the plea agreement. Are those your initials and is that your signature?
Yes, ma'am.
Let's see one here. I just need to get around my. Mr. Parkins, before you initialed those paragraphs and signed that document, did you read through it carefully?
Yes, ma'am.
Did you also review the plea agreement with Ms. Schweinsker?
Yes, ma'am.
Did you understand the plea agreement?
Yes.
And do you understand the rights in the defendant's right section?
Yes.
Mr. Perkins, do you understand that when you plead guilty that you give up your right to have a trial by jury?
Yes.
Do you understand that by pleading guilty that you are giving up your right to remain silent?
Yes.
Do you understand that by pleading guilty that you are giving up your right to confront anybody who's accusing you of these offenses?
Yes.
And do you understand that by pleading guilty that you are waiving or giving up all of the other rights during the advising of rights section of your plea agreement?
Yes, ma'am.
So before you appeared in court this morning, did you consume any alcohol, drugs, or medications?
No.
Do you believe that you are thinking clearly today and that you understand these proceedings so far?
Yes.
Mr. Perkins, according to your plea agreement, you are a citizen of the United States. Is that correct?
Yes, ma'am.
Sir, has anybody forced or threatened you into pleading guilty?
No.
Are you pleading guilty today because it is your choice to do so?
Yes, ma'am.
Has anybody promised you anything to get you to plead guilty other than what is in the plea agreement?
No.
Do you understand that if I accept your plea agreement, that I will sentence you according to the terms of the plea agreement?
Yes, ma'am.
Do you understand that your plea of guilty may cause harsher sentences for any crimes that you might commit in the future?
Yes, ma'am.
And again, sir, you are pleading guilty today to possession of marijuana and domestic battery, both of which are Class A misdemeanors. A Class A misdemeanor is punishable by up to 1 year of incarceration and a maximum fine of $5,000. The crime of domestic battery is also a crime of domestic violence. And what that means is at the time of your sentencing, I will make a domestic violence determination. And that means that you will be prohibited from possessing firearms and ammunition. It means that you may also have restrictions in parenting time with minor children. Do you understand that?
Yes, ma'am.
Sir, have you reviewed these charges?
My lord, woman.
And did she
Stop
explain to
talking.
you that, or the possible penalties and what the state would have to prove in order to convict you?
Yes.
Ms. Schweinsker, does your client waive the formal reading of the charging information and statutes?
He does, Your Honor.
Mr. Perkins, do you understand what the state would have to prove that you committed these offenses?
Yes.
And do you also understand the possible penalties that you face?
Yes.
Mr. Perkins, do you understand that one of the terms and conditions of your placement on probation is that you cannot commit any new criminal offenses?
Yes.
Do you understand that?
Yes.
Do you understand that by pleading guilty to crimes that occurred while you were under the supervision of probation means that you are also admitting that you violated your placement on probation?
Yes, ma'am.
And with everything that we've discussed today, do you still want to plead guilty pursuant to your plea agreement and also admit
This
that you
wasn't a
violated your placement on
discussion.
probation?
Yes, ma'am.
You just
Thank you.
threw
Actual basis,
1,000
please.
words at him.
Thank you. Joshua, let's start with the domestic battery case. Look back to September 4th of 2022. On that date, were you in Elkhart County, state of Indiana?
Yes, ma'am.
And you were in a relationship with Denise Haggerty at that time, is that correct?
Yes, ma'am.
You're still in a relationship with her?
Yes.
The two of you have children together, is that correct?
Yes.
Do you admit that at that time you touched her in a rude or angry manner?
Yes.
And you're guilty of domestic battery, correct?
Yes, ma'am.
Turning your attention next to May 10th of this year, you admit that on that day you were found in possession of marijuana.
Yes, ma'am.
You knew there was marijuana, you had no medical or legal reason to be in possession of marijuana, is that correct?
Correct.
And you had a prior conviction for possession of, excuse me, an offense involving drugs out of Elkhart Superior Court number 3 from June 25th of 2018. Is that correct?
Yes, ma'am.
Thank you. And then also you were placed under probation supervision in July of 2019. Is that correct?
Yes, ma'am.
And you admit that it's a violation of the terms of your probation to have not obtained a substance abuse evaluation that you were ordered to do?
Correct.
And you didn't complete your community service hours on time, is that correct?
Correct.
And you were also charged with the new offense of possession of marijuana that you just pled guilty to, is that correct?
Correct.
You admit that those are violations of the terms of your probation that you were placed under at the time?
Yes.
Nothing further on a factual basis.
Mr. Leal,
No questions based on that.
the court will find that the defendant has tendered a knowing voluntary plea and admission. Counsel, do we need to set these matters out for victim notification?
Judge, she's here today. If we could
I think we
proceed.
had anticipated doing notification, but the victim is present. I think we can go ahead. If the court's
The
comfortable.
parties are comfortable, the court is comfortable. Arguments, Ms. Weinster.
So
Thank you, Your Honor.
I know they say it in court a lot. I don't know if Zach is still here. He will agree with this. But guys, when we're going through these dockets to find these court cases, you should see how many fentanyl death cases we are combing through. Now, before when I would go through a docket, I knew a couple things right away. I was going to get overwhelmed with domestic violence and DUIs over again. And then children, men with children, they started growing a bit, and they still are. But now there's so many deaths with fentanyl. People attempted murder, blah blah blah, because they gave their girlfriend a pill. They gave their boyfriend a pill at a party. He's dead now. And there are so many throughout these dockets now. It's getting crazy. You gotta talk to your kids, even though your kids are old. Talk to them anyway.
Joshua's been very cooperative during this process, and when we spoke, Denise was there as well, and they are a family unit. Everything's going well with them. They have children together. They're engaged. They're looking to get a house. Josh is working full time. They just got a new vehicle. Everything's going well for them. And I think the problem that was causing everything to kind of fall apart is that Joshua was having some substance abuse problems in the past. That was causing relationship problems in the past. That was causing most of their problems in the past. He talked a lot about the fact that he is clean and that that's no longer an issue for him, and it's caused much healthier relationship between he and Denise. So I'm hopeful that that will continue and that he will be able to get through his community correction sentence and his probationary term. The probation case, it looks originally as if it was a 1-year sentence. However, when you look closer, it was an error on that sentence. It was actually a 60-day sentence out of Superior 3. And he was time served on that when he was in the jail back in June. So that case, I have an order if you wanted to see, but Judge Cataldo released him back in June from the jail after a 30-day stint.
Okay, there you go, right there. Oh, there we go, right there. Judge Cataldo. Remember, you gotta remember, we were just watching her. She's the one, with, she has brown hair, black hair, dark hair. And when we were watching her, I told you, they're gonna go to jail and they have to do this amount of things, and she watches every report. And then they have to send her a letter to say, hey, let me out. I did what I was supposed to do. Let me out of jail. Then she will let them out of jail. he was one of the ones. He went into jail. She gave him classes he had to take, or recovery you have to do for recovery, whatever you have to do when you go in for recovery. And then he sent her a letter from inside jail. He sent her a kite, and she let him out after 30 days. So those other people, like, she looks at the report. She looks at every report for the people she sends into jail. But she doesn't, like, automatically let them out. They have to do what they have to do, and then they have to send her a letter. You have to write her a note from inside jail. And he did it. Now we just saw it happen in real life.
And he continued to report to probation because his probation officer told him to continue to report. So even though he was time served back in June, he did continue to report on that cause of action. And he's been drug screened, he said, and he's been clean on those drug screens. So that's positive and hopeful. So we would just ask that the plea agreement be accepted. And as far as the community corrections report date, 30 days. If we could have a 30-day report date, thank you.
Martha, thank you so much for the cheers. Thank you so much. I don't think that popped up. Maybe it did. Did it pop up on the screen? But thank you so much. Thank you.
Mr. Leon.
State's asking the court to accept the plea agreement. I think Ms. Schweinsker did a good job of laying out kind of the fabric of the set of cases. Because
No,
Mr. Perkins has accepted.
This judge isn't the same way. This judge sends you in, and then you stay in for whatever she said, whatever she wrote down in the paper.
Responsibility for what he's done, including on the violation. We believe this is an appropriate recommendation and sentence. Thank you.
Thank you. And Joe, the probation one, you go down even.
I did a form for it. I don't know if they wanted to do it before or after. I can make an inquiry after court today.
Okay, so I think the new form they gave us anticipates a prior placement.
I wrote that on there as well, so.
Okay. All right, so Mr. Perkins, based upon the information provided, I will accept your plea agreement and sentence you according to the terms of the plea agreement. I will start first with cause number 2201-1905-CM968. In that cause of action, the court will accept Ms. Schweinsker's representation that your time served in that cause of action obscured. And once the court awards you an additional 30 days credit, or I should say a total of 30 days credit, plus good time credit, then you have satisfied that 60-day sentence, and it will show that you were unsatisfactorily discharged from probation supervision. Now in cause number 20D01-2505-CM989, on the charge of possession of marijuana as a Class A misdemeanor, I will sentence you to 180 days at the Elkhart County Correctional Facility. I will award you credit for 2 days served plus equal good time credit. And for the remaining portion of that sentence, I will authorize alternative placement through Elkhart County Community Corrections at a level of supervision that they deem appropriate. And pursuant to your plea agreement, you agree that you are going to obtain an addictions evaluation plus any recommended follow-up treatment. I will also order that you participate in any other programming or treatments that your case manager believes will benefit you. I will order in that cause of action that you pay the mandatory court costs, which includes the $200 drug interdiction fee. No additional costs will be imposed. Consecutive to that cause of action and cause number 20D01-2505-CM1027, on the charge of domestic battery as a Class A misdemeanor, I will sentence you to 1 year at the Elkhart County Correctional Facility. And Ms. Schweinsker, there is no credit in that case, correct?
Correct.
There is no credit to award in that cause of action. The entire sentence is suspended on probation at a level of supervision deemed appropriate by the probation department. The court will order Mr. Perkins that you participate in any programming or treatment that your probation officer believes will benefit you. Do you understand that?
Yes, ma'am.
And there is not a request for a no contact order. Is that correct, Mr. Leon?
That is correct, Your Honor.
The court will decline to impose a no contact order. If there was a pretrial no contact order, it is dismissed. The court will make a domestic violence determination. Mr. Perkins, what that means for you is that you are prohibited from possessing firearms and ammunition. It means that you may also have restrictions in parenting time with minor children. Do you understand that?
Yes, ma'am.
The court will impose the mandatory court costs only, which includes the $50 domestic violence fee. And it doesn't look like we have any bonds in place, is that correct?
I did bond out, yes.
Okay, for the domestic battery charge or the possession of marijuana?
Possession.
Okay.
It was possession. Sorry about that.
One of my charges, Judge, I don't know. I can't keep them straight.
A surety bond. Yes, that was a surety bond. The court will show that the surety bond that was posted in CM 989 is ordered released. The court will show that the appearance of the public defender's office is withdrawn on all three causes of action. Judgment of conviction is entered in CM 989 on count 1 possession of marijuana as a class A misdemeanor, and in CM 1027 on domestic battery as a class A misdemeanor. Any remaining counts are ordered dismissed. Ms. Schweitzer, other than putting a date for community corrections, is there anything else?
I don't believe so. No.
Mr. Finneran, is there anything else?
No, thank you, Your Honor.
Mr. Perkins, I will order that you report to Elkhart County Community Corrections for an orientation on November 19th at 6 p.m. Ms. Schweitzer is writing that down on the Elkhart County Community Corrections pamphlet. The information about Elkhart County Community Corrections is contained in that pamphlet. I'm also going to send you down to the probation department before you leave so that you can sign any terms of probation or anything necessary.
It is.
Probation.
Okay.
Even though
Well,
you're
right now it's at
Elkhart County Community Corrections,
6,137.07,
the terms of probation
which is
start
720,
right now.
not 360.
That means if you violate your placement on Elkhart County Community Corrections, don't be surprised if probation also files a violation. Okay? So go down to the probation department, which is at the end of the hallway before you leave.
Okay, thank you.
Thank you.
Thank you.
Pierre Talley.
This is cause number 20-1-2504-F591, Steve Indiana versus Pierre Talley. Sir, raise your right hand. Do you swear or affirm under the penalties of perjury the testimony that you provide to this court with the truth?
Yes.
Can you tell me your full name, please?
Pierre Talley.
Thank you. The court shows that the defendant appears in person and also with attorney Chelsea Saracen. The state appears by DPA Ashley Young. And I show that we are set today for a change of plea hearing. Ms. Saracen.
Thank you, Your Honor. I had attempted to reach out to the assigned DPA again to see if there was what the plan was or if there was going to be a potential resolution. I did not receive a response prior to today, and Mr. Talley had already paid for a train ticket to come here from Ohio that he was not able to be reimbursed for. So I guess we're having the hearing. My thoughts was just setting it for trial in light of that. But Mr. Talley is reluctant to do that just yet. So I guess I'm asking for a continuance to see if this can be resolved prior to taking up space on the trial calendar.
Mr. Leon.
No objection to the continuance, Your Honor. I think that there's a chance, but I don't know how close the parties are in terms of getting a resolution, be it short of trial. But I think particularly because Mr. Talley's interested in seeking a resolution, we have no objection.
During a stream, it'll have to be
yes, it is.
fixed before next stream.
So
before OJ.
Ms. Saracen, I share
Monica, thank you
your
for the cheers.
perceived frustration as well as your clients. Okay. And you just need to, client just needs to know one way or another if there's going to be a plea tendered that is acceptable or getting on the trial calendar. Mr. Talley, I can understand that you might have some concern about getting it on the trial calendar, that could cause the state to either revoke offers or change the offer that's not favorable to you. But at some point in time, we just need to know how to go forward with the case. So Mr. Kelly, I will allow one additional continuance to find out if you're going to be able to resolve this case short of trial. If not, certainly it's not a concern from the court's perspective, putting it on the trial calendar. That's something that upsets the court. Hopefully that doesn't cause any other issues for you, but for everybody's sake, especially yours, we just need to know how this case is going to get resolved. All right, Ms. Harrison, do you have a time frame in mind? Well, like I said, Mr. Talley lives in Ohio, so that does present some challenges with us being able to review things together. I guess I would ask at least 45 days and an attorney conference set in the next couple of weeks. December 8th. That would be fine.
So, yes, Your Honor, that works for the state. Thank you.
The court shows on motion of the defendant and without objection by the state, this cause of action is continued to December 8, 2025 at 8:30 a.m. The court shows that the delay is chargeable to the defendant for purposes of penal worth. Anything else, Ms. Harrison? No, thank you. Mr. Young?
Did we want that attorney conference date?
Oh, yeah, I'm sorry, when was that? In the next couple of weeks, Your Honor. Thank you, Mr. Young, for reminding me of that.
All right, we got one more chance of magic. Let's go. Move on to the next person.
Ms. Harrison? Or sooner?
I can even help that a
If
little
we could
bit.
have something sooner.
Is since been released.
If we could have something sooner.
I'll just leave it alone. I'll just stop touching it.
Can we do November 5th? November 5th, please, at 1 p.m. Thank you. Great, thank you.
You can print or interpret case.
Mr. Aguilar, raise your right hand to be sworn. Do you swear or affirm that you will justly, truly, and impartially interpret to the clients the oaths about to be administered to them, questions that shall be asked of them, and the answers they shall give to such questions relevant to the cause under consideration before this court will apply?
I do.
Can you tell me your full name, please?
You're welcome. Adrian Aguilar.
Alman Arahu.
This is State of Indiana versus Oman Araho. Cause number 20B01 202 F6181, 20B01 2502 F6196, 20D01 2503 CM442, and 20D01 2503 CM443. There's also a companion protective order matter, clause number 20D01 2502 PL154. Sir, raise your right hand to be sworn.
Levante su mano derecha para ser colocado bajo juramento.
Do you swear or affirm
Si usted jura o
under the
afirma
penalties of perjury,
bajo las penalidades de perjurio que el testimonio que usted le proporcionará a ese juez será la verdad? Sí. Yes.
Thank you.
Gracias.
Please tell me your full name.
Por favor, dígame su nombre completo.
Olman Edison Araujo.
Olman Edison Araujo.
The court shows that the defendant
Se dice
appears
que
in
el acusado
person
comparece en persona.
and with respect to the criminal
Con
causes of
respecto a
action,
las causas de acción
Attorney
criminales.
Mark Altenhoff,
Con el abogado Mark Altenhoff.
State appears by
Y el
DPA
estado
Josh Leon,
comparece con el fiscal adjunto Josh Leon.
certified interpreter Adrian
Intérprete
Aguilar
certificado
also
Adrian Aguilar
appears
también comparece.
in the protective order cause of
En
action.
causa de acción de la orden protectora.
Mr. Oman,
Señor Olman, perdón.
Mr. Araujo
Señor Araujo.
appears as a self-represented litigant
Aparece como litigante representado por sí mismo.
and the petitioner does not appear.
El peticionario no comparece.
Mr. Altenhoff, what are we doing
Está
today,
bien,
please?
señor Altenhoff, ¿qué vamos a hacer el día de hoy, por favor?
Thank you, Your Honor.
Gracias, su señoría.
Judge, on
Pues,
the criminal matters,
en eso, en los
I am
asuntos
asking for a
criminales estoy pidiendo una
continuance.
postergación.
The last time my
La última
client
vez que mi
appeared
cliente
before you, he was
compareció
in
ante usted, él
custody.
estaba en la custodia.
He's since been
Desde ese
released,
entonces ha sido liberado.
and I'm asking that
Estoy pidiendo que usted
request that he go make an appointment with
solicite
me
que
so that we
él vaya
can.
y haga una cita conmigo.
You know what's unbearably messed up about this? Is we can't hear normal people speak because they're nowhere near a microphone. Not normal people. We can't hear normal court people normally during the day. Not normal people, normally, in a normal setting. We can't hear them because they're nowhere near a microphone. But they gave this interpreter a microphone right by his mouth. Now we can't hear anything.
Conmigo para que nosotros podamos
Come to an agreement on the criminal
llegar a un
matters.
convenio por respeto a los asuntos criminales.
So I'm asking for a
Entonces, estoy pidiendo una postergación.
Mr. Leon.
Just gonna practice my
No
Spanish.
objection, Your Honor.
Ninguna objeción, su señoría.
Mr. Alton Hoff, December
Señor
1st.
Alton, primero de
That's fine,
diciembre.
Judge. Thank
Eso
you.
está bien, pues, gracias.
That's agreeable to the state.
El Estado está de acuerdo con eso.
On motion of the defendant
Solicitud del
and without
acusado
objection by the state,
y sin objeción por el Estado.
these causes of action are continued
Están siendo postergadas
to December 1st,
al día primero de diciembre
2025
del 2025
at 8:30
a las
a.m.
8:30 de la mañana.
For the pending matters,
Para los asuntos
the
pendientes,
delay is
la
chargeable to the
dilación es
defendant
atribuida al acusado
for purposes of criminal rule
para los
4.
propósitos de la regla criminal 4.
Sir Raffle,
Señor Araujo,
there was also a protective order
también hubo
petition that was
una
filed
petición de orden de protección que fue levantada
by Ms. Escobar.
por la señora Escobar.
The court did
El
grant
juez sí concedió
that order of
esa
protection,
orden de protección
and I set this matter for hearing
y programé este asunto para audiencia el día de hoy
to address additional requests that were made
para dirigir
in that
algunas
protective
solicitudes
order.
adicionales que se hicieron en esa orden de protección.
Have you received a copy of that
¿Ha
petition?
recibido usted una copia de esa petición de la orden de protección?
Sí, cuando estaba en la detención.
Yes, when I was in detention.
What, if anything, are you asking the court to do on that
Sí.
matter today?
Si hay alguna cosa que usted le esté pidiendo al juez que haga el día de hoy con respecto a ese asunto.
Es por ahora no, porque tengo que más información de la persona.
For the time being, no, I need some more information with respect to that.
Como no puedo acercarme a mis hijos, si pudiera acercarme a mis hijos, pero necesito más información para poder acercarme.
Since I can't get close to my children, I would like to be able to get close to my children, but I would need additional information to be able to get close to my children.
As far as any request that was
Con
made
respeto a alguna solicitud que se
or
haya hecho,
any restrictions in
para
parenting time,
alguna restricción en tiempo de crianza con niños,
I'm not going to take action on that.
yo no voy a tomar acción con respecto a eso.
I don't know if there
Yo no
is
sé
any pending
Si
custody
haya
case
algún caso de la custodia que esté
involving
pendiente,
you
involucrándolo a usted
and the mother of your
y a
children.
la madre de sus hijos.
If there is,
Si
then
lo hay, entonces
whatever
lo que
was decided in that
haya
case,
sido decidido en ese caso,
you have to cooperate with.
usted tendrá que cooperar con eso.
If you don't have a pending
Si
case,
usted no tiene un caso pendiente
and if these children
y
were
si estos niños
born
nacieron
without you and the mother being married,
sin que usted y la madre estuvieran casados,
then more likely than not,
entonces es más probable
she has full
que ella
custody
tendrá
under
la
Indiana law.
custodia completa de los niños bajo la ley de Indiana.
There is a no contact order
Si hay una orden de
in
no
the criminal
contacto
case.
en el caso criminal,
So even if
así es que
I
Hi, Kelly,
aunque
love.
the
yo
protective order,
desestimara
Josh.
la orden de protección,
there still is that no contact
todavía
order
hay esa orden de no
that
contacto
prohibits you from having
que lo
contact.
prohíbe de tener a usted contacto.
So what I
Así es
intend to
que
do
lo
today
que yo tengo las intenciones de
Unless
hacer
you
el
have
día de
an
hoy,
objection,
solamente que usted se oponga,
is confirm the
es de
order of
confirmar la
protection,
orden de protección,
but
pero
decline to take any
voy a
action
rechazar
on
tomar
the
alguna
request to
acción con
restrict
respecto a la
your parenting time.
solicitud para restringir su tiempo de crianza.
Do you have any questions about what I explained?
¿Tiene alguna pregunta sobre lo que acabo de explicar?
No está bien.
No, everything's fine.
What you need to do,
Lo que
Mr.
se
Rocco,
necesita hacer, señor
is
Araujo,
go to the public
es ir
defender's
a la
office
oficina del
and
defensor
schedule an
público
appointment.
y programar una cita.
They are on the fourth floor,
Ellos están en el cuarto
so
piso,
one floor up
así es que un piso arriba,
at the end of the
al
hallway.
final del pasillo.
So go there before you leave.
Así es que vaya ahí antes de irse. Okay, that's fine.
You just need to schedule an appointment with Mr. Altonhoff.
Simplemente usted necesita hacer una cita con el señor Altonhoff. Okay, gracias. Thank you.
Thank you.
Gracias.
That's all we need, Adrian, 4 till 11.
Okay.
Yeah.
Great. Are you ready?
Hello, another Smith. Hello, hello.
Call Tony.
Hi, Terry.
This is cause number 2201-2504 F597, State of Indiana versus Paul Cronin. Sir, raise your right hand to be sworn. Do you swear or affirm under the penalties of perjury the testimony you provide to this court will be the truth?
Yes.
Can you have a seat, please? And tell me your full name.
Paul Thomas Cronin.
Thank you. The court shows that the defendant appears in person and also by attorney Mark Altenhoff. State of Indiana appears by DPA Josh Leong. And I show that we are set today for a change of plea hearing. Mr. Altenhoff.
Thank you, Your Honor. Judge, my client he shattered his ankle in an ATV accident. And so my communication with him has been a little bit limited. I'm asking for a continuance today, also an attorney conference, and I would ask that you
He shattered
order,
his ankle.
community corrections evaluations for my client
So
as
you
well.
can't talk to him?
We had one from Elkhart County already.
Get that already, Judge? Okay.
You did file that motion back in August.
Got it. Okay.
It looks like we have both Michiana Community Corrections and Elkhart.
All right. So I would forget that request, Judge. I would ask for a continuance and also an attorney conference for November the 5th, Judge.
Poor man.
If I could have an attorney conference, then I think we can
Hey,
try
man.
and get this case resolved.
Man, you shattered your ankle and you were able to talk to us fine. Absolutely fine. Let's see if she's any better. There we go. Watch him walk out of here. See?
Just coming.
Let's watch him walk right out of here.
Okay. He already has one, Judge.
Okay, thank you.
All right. Thanks. Thanks.
No, come this way. Come this way.
Sean Washington.
This is cause number 2201-2504 F6380, State of Indiana versus, is it Dejanay? Yeah. Washington. Raise your right hand to be sworn. Don't roll your eyes at me, Joe. Do you swear or affirm under the penalties of perjury the testimony that you provide to this court will be the truth?
Yes.
Can you have a seat, please? And please tell me your full name.
Dejanay Washington.
Thank you. The court shows that the defendant appears in person and also by attorney Mark Altenhoff. State of Indiana appears by DPA Josh Leong. And I show that we are set today for a change of plea hearing.
Okay. Thank you, Your Honor. Judge, my client and I have been in constant communication. She had a phone appointment with her on October the 2nd. She accepted a revised plea offer from the state of Indiana. I thought she was going to come in to sign the plea agreement. She hasn't yet. We could either try and get that done today, Judge, if you'd be willing to set our case aside, or I would request continuance. We've definitely reached an agreement on this case, though.
Mr. Altenhoff, I would be okay recessing the case and just seeing if that's possible. If it's too quick, then we can address that.
All right.
So Ms. Washington, we're going to recess your case for a little bit so we can see if you'll have enough time to work with Mr. Altenhoff.
Okay.
If so, we can go forward this morning. If not, if you don't have enough time, if you have more questions, then we can talk about resetting the case, okay?
Okay. Have a seat out in the hallway. I'll come see this. Okay.
Okay.
Stacy Wetter.
This is cause number 20D01-2502 F6250, State of Indiana versus Stacy Wetter. Please raise your right hand to be sworn. Do you swear or, you're okay. Do you swear or affirm under the penalties of perjury the testimony that you provide to this court will be the truth?
Yes.
Can you tell me your full name?
Stacy Ray Wetter.
Thank you. The court shows that the defendant appears in person and
You can
also
tell
with
me if
Attorney
it's
Mark
gonna rain
Altenhoff. State of
soon.
Indiana appears by DPA Josh Leong. And I show that we are set today for a change of plea hearing. Mr. Altenhoff.
Thank you, Your Honor. Judge, similar request from the previous case. We have reached a plea agreement in this case. Stacy was here in the old courthouse the last time she was here, and she was very sick. And so we continued her case to today. She has been down in Brown County, Indiana, living there, but she's back now. We have reached a plea agreement. I would either ask for a continuance or if you could set her case aside so that we can
Monica, thank you.
we might be able to get this case resolved again today.
Mr. Altenhoff, what is your preference?
Thanks for giving me a cat though. Oh,
Judge,
is that a
she's asking
corgi?
for-
That's a
Okay,
corgi.
she's
Is that a
asking for a
fox?
continuance, so I would ask
What
for
is
that as
that?
well.
December 8th.
December 8th?
Yes.
All right, turn up, Judge. Thank you.
Mr. Leong, does the state have any objection?
No, Your Honor.
The court shows on motion of the defendant and without objection by the state, this cause of action is continued to December 8th, 2025 at 8:30 a.m. The court shows that the delay is chargeable to the defendant for purposes of criminal report.
I'm going with fox.
Does she need to schedule an appointment with you?
She does, Judge. Thank you.
Wait,
Sorry,
no.
that's okay.
No,
It's on-
not a
it's on the
fox.
floor.
Fox don't have curly little back tails. Fox have long, fluffy tails. So I'm going back to see. It looks like that's what I think, but look at the tail. It's a fox. Foxy lady.
So go up one
Sent
floor
me a
and scan the
fox.
hallway. Thank you. All right, thank you.
Thank you. Right now. Okay. All right. Thank you.
Dontrell Newman.
This is State of Indiana versus Dontrell Newman, cause numbers 20D012408 CM1484, 20D012408 F6947, 20D012410 CM1857, and 20D012506 CM1299. So raise your right hand to be sworn. Do you swear or affirm under the penalties of perjury the testimony to be provided to this court will be the truth?
Yes, ma'am.
Thank you. Please tell me your full name.
Dontrell Newman.
Thank you. The court shows that the defendant appears in person and also with Attorney Mark Altenhoff. The state of Indiana appears by DPA Josh Leong. And I show that we are set today for sentencing. The probation department files a pre-sentence investigation report on October 9th. Are there any corrections or additions?
Your Honor, my client indicated that her mother passed away this week. Okay. So Judge, with my sympathies to him, I just found this out just now. That would be the only change that we have to the PSI.
Okay. And I'm sorry to hear that also, sir. Mr. Leong, does the state have any corrections or additions?
No, Your Honor.
Mr. Altenhoff, arguments on your client's behalf, please.
Judge,
Wait a minute. Which mother passed away, Mr. Newman? I'm sorry.
Kimberly Ross. The one that adopted me.
Okay, October 8th. I see. That's listed in the pre-sentence investigation report.
Okay.
Okay.
Thank you, Your Honor. Your Honor, the plea agreement does call for, first of all, I guess we'll start off with my client really does not have that much of a criminal history at all. The plea agreement does call for community corrections for F6947, also CM 1484, and then finally also on CM 1299 for executive cases. He does qualify for Elkhart County Community Corrections. It's a stipulated plea, Judge. He came back as a matter of risk to reoffend. We would ask that you adopt the terms of the plea agreement and sentence him according to the terms, Judge. Thank you.
Thank you, Mr. Newman. Is there anything you'd like to say on your own behalf?
I do want to say and apologize to everyone in the court for things that situations I put myself in, and basically the things I did in result to that. Yes. Apologies to everybody.
All right, thank you. Mr. Leon.
Yes, Your Honor. The state's also asking the court to accept the plea agreement. Mr. Newman has accepted responsibility for his actions. He's agreeing to do a total of 3 years on community corrections, and we think that's an appropriate duration and level of placement for his sentence. Looking through the pre-sentence investigation report, being a moderate IRAS 7 on the ODERA, we do think that community corrections is warranted. The state is requesting a no contact order in F6947, which is the victim is Jennifer Gonzalez Navas. We're not requesting a no contact order to any of the other cases, but I would just note that the victim in CM, sorry, Your Honor. 1484 is asking for restitution. That victim impact statement was included in the PSI. So we would ask that to be referred to probation. But beyond that, Your Honor, we're just asking the court to accept the plea agreement, as we do think it is appropriate in light of his relative lack of criminal history before this set of cases. So we're hoping that this will be a good opportunity to get Mr. Newman back on track. Thank you.
Thank you. Mr. Altenhoff, what about the restitution request?
Yeah, he's willing to pay that, Judge. Thank you.
Okay, and I'm not sure, does this apply to a charge that's dismissed or being dismissed?
You're talking about the 20297, Judge?
Correct. To a Tammy Smith.
CM 1484.
Okay. All right, give me just a moment here. All right, based upon the information provided, the court will accept the defendant's plea agreement and sentence him according to the terms of the plea agreement. There was a discrepancy in the credit time on the pre-sentence investigation report and a credit memorandum. So in S6 947, the pre-sentence investigation report listed 32 days, but the credit memorandum had 33 days.
Say that again, Judge.
The credit memorandum had 33 days.
Right.
And
I went into
PSI
work
had
early
32.
yesterday and then I stayed late.
So my thought
No.
was the 33 days would be applied.
What we would ask, Judge. Thank you.
Mr. Leon, does the state have anything to add?
No, Your Honor, the state agrees. Looking at the credit time memorandum, I see it adding up to 33, so I have no issue with their calculation.
That was my thought also. All right, so starting first with cause number 20D01 2408 F6947. In charge of strangulation as a level 6 felony in count 1. The court will sentence the defendant to the aggravated sentence called for in the plea agreement. Because that was an agreed upon aggravated sentence, the court will decline to make any findings regarding aggravating and mitigating circumstances. That aggravated sentence is 2 years at the Indiana Department of Correction. The court will award the defendant credit for 33 days served. Actually, I'm going to do 35 because I'm going to add the 2 days.
Okay.
From CM 1857. So the court will award the defendant credit for 35 days served plus the 10 credit. For the remaining portion of that sentence, the court will authorize alternative placement at Elkhart County Community Corrections at a level deemed appropriate. The court will order that the defendant participate in any programming or treatment that his case manager believes will benefit him. And the court will also impose a no contact order with Jennifer Gonzalez Navas. So what that means for you, Mr. Newman, is that you may not have any contact with that person directly. So you cannot contact her yourself. You cannot have any contact with her indirectly, meaning that you cannot have somebody contact her on your behalf. Do you understand that?
Yes, ma'am.
I will order that you submit to a DNA sample at your own expense if required. And I believe that it also requires the court to make a domestic violence determination. Did we make that record previously?
Yes,
I think that we did.
we did.
We'll also make a domestic violence determination. And what that means for you, Mr. Newman, is that you may not possess firearms or ammunition. It means that you may also have restrictions in parenting time with minor children. Do you understand that? Consecutive to that cause of action, in cause number 20D01 2408 CM 1484, on count 2 intimidation as a class A misdemeanor, I will sentence you to 180 days at the Elkhart County Correctional Facility. Looks like there's no credit in that cause of action. For the entire sentence, the court will authorize alternative placement on Elkhart County Community Corrections at a level of supervision deemed appropriate by the probation department. And the court will also impose a no contact order with Tammy Smith pursuant to the plea agreement. Same thing, Mr. Newman, do you understand that you cannot have any contact with Ms. Smith directly, meaning that you cannot contact her yourself, and you cannot contact her indirectly, meaning that you cannot have somebody contact her on your own behalf or your behalf? Do you understand that?
Yes, ma'am.
The court will also show that you have agreed to pay restitution to Ms. Smith, and that was in sum of $202.97. Is that correct?
Yes.
All right, Mr. Newman, I will order that you pay that restitution in full before you finish your supervision on Elkhart County Community Corrections. Do you understand that?
Yes, ma'am.
And that restitution can be paid to the clerk of the court, and that's downstairs on the first floor. Next, the plea agreement. The court will that you participate also in any programming or treatment that your case manager believes will benefit you in that cause of action as well. Do you understand that?
Yes, ma'am.
And consecutive to those two causes of action, in cause number 20D01 2506 CM 1299, on count 1 invasion of privacy as a class A misdemeanor, the court will sentence you to 180 days at the Elkhart County Correctional Facility. I show that you are entitled to receive credit for 6 days served plus equal good time credit. And for the remaining portion of that sentence, I will authorize alternative placement on Elkhart County Community Corrections at a level deemed appropriate. And Mr. Leon, is the state not requesting a no contact order in that cause of action?
That's correct.
The court will decline to impose a no contact order. If there was a pretrial no contact order, it is dismissed in that cause of action only. And same thing with the other cases, Mr. Newman, I will order that you participate in any programming or treatment that your case manager believes will benefit you.
Yes, ma'am.
All right, the court will order the defendant pay the mandatory court costs only. And that includes in F6947, the $50 domestic violence fee. The court will show the appearance of the public defender's office is withdrawn in all causes of action. Looks like we might have 2 cash bonds in CM 1484.
It sounds like it.
In
Sounds
CM
like it'll put hair
1857.
right on your chest.
Mr. Newman, does the court
Waking the
have
neighbors.
information to release
It's
those
high
cash
caffeine.
bonds and apply those credits
sir.
towards your outstanding court costs?
Yes, ma'am.
The court will order that. I will show that judgment of conviction is entered in CM 1484. Actually, let me back up a little bit. Sorry, I said too many causes of action. Okay, CM 1484, intimidation on count 2 is a class A misdemeanor. In F6947, on count 1, strangulation as a level 6 felony. And in CM 1299, on invasion of privacy as a class A misdemeanor. Any remaining counts in those causes of action are ordered dismissed. Furthermore, cause number 20D01 2410 CM 1857 is dismissed in its entirety with prejudice. All right, Mr. Newman, I'm going to give you a date to report to Elkhart County Community Corrections. I will order that you report for an orientation on November 12th at 6 p.m. Mr. Altenhoff has the brochure and he's writing down the date and time for the orientation. The address and contact information is listed in that brochure for Elkhart County Community Corrections. If you have any questions about what you need to do ahead of time, hopefully that brochure will answer those questions for you. If not, you should contact Elk Park County Community Corrections ahead of time. Do you have any questions?
No, ma'am.
Mr. Altenhoff?
Nothing further. Thank you.
Mr. Leon?
The same, Your Honor, nothing to state.
Thank you.
Timothy Bobby.
This is cause number 20-01-2406-F6692, State of Indiana versus Timothy Bonney.
Judge, my client is obviously not here today. That may be somewhat on me. I had a phone appointment with him on September 25th. The basis of the probation violation, this case that's pending in Albany City Court.
No. You, sir, are a mess today. You need to go and unfix yourself. Go fix yourself. We're gonna pop over to OJ. Guys, thank you so much for coming out. I really, really, really appreciate it. I'll see you all again very soon. All right, have a great day. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so